Hi, I am Sterling Watts with dailyunconstitutional.com, and I'm continuing with this sequence of videos which are related to the growing need for the exercising of our natural inalienable rights, which were enumerated in the United States Constitution, but which were granted to us by God, or if you don't want to look at it in those terms, they are granted to us because we are each individually self-governed beings. The event I'm going to talk about involves a man named Terry Holcomb Sr. who is running for state representative in District 18 in Texas, I believe in the Libertarian Party. I'm not sure. I believe he is running as an independent at least. But the details of this event were just outrageous, and it was through this event that I discovered KrisAnne Hall. If you're not familiar with KrisAnne Hall, I suggest you look into it, and I will be providing some of her information, constitutional information products here on the site as we grow into it. We're trying to develop another menu item to offer these things, but that's kind of in the growth process. But if you want to keep up on that, why, I invite you to just get your name on our mailing list, and when it gets developed, you'll start receiving this important information. Go to the link at the bottom of the video, but watch the video first, please. But go to the link at the bottom of the video and provide your name and email address, and you'll be on the list to be kept up to date with what's going on in the world of protecting your constitutional rights in the United States. Now, Terry Holcomb Sr., as I said, is running for office in Texas, and about a month ago this event occurred in a Texas courthouse. I don't even remember what county it was, but what happened was that the county was holding a public meeting, the public meeting being to hear redress from the public on an issue to which there was quite a bit of public opposition. The county didn't really want to hear any public opposition, so they shut the meeting down before anybody had a chance to speak any opposition. Terry Holcomb didn't stand for that. The judge tried to adjourn the meeting, and of course the designated reason for having the meeting was to hear public redress on whatever this topic was. So Terry Holcomb Sr. stood up and protested and demanded to be allowed to speak. And in spite of the fact that the meeting was already formally adjourned, he was charged with disrupting a public meeting or some such charge, and arrested on a bogus charge, and he spent some 48 hours in jail because he had refused to be denied the opportunity to be heard, which is guaranteed in the United States Constitution. Now, some people say, yeah, but this is a local issue, but we got to remember there's a 10th Amendment. The 10th Amendment says the rights guaranteed in the Bill of Rights, or anywhere in the United States Constitution, are universal and cannot be declared null and void by any state. So it doesn't matter if it's a federal issue, a state issue, or a local issue, your right to be heard is universal. So, Mr. Holcomb spent a couple of days in jail, and if you listen to the audio commentary by KrisAnne Hall, you'll be very enlightened. We discovered KrisAnne Hall here recently, and we're including some of her materials in our growing list of stuff. Now, why even is there a Bill of Rights? And why would I take the position that the Constitution was written to protect the people against the unjust actions of a tyrannical government? Well, maybe that's because the history of the activities of the Continental Congress in 1789 verified that position. That's what the American Revolution and the formation of the government afterwards was all about. Now, there were two camps in the Constitutional Congress, and the Federalists actually argued against the creation of a formalized Bill of Rights, but that wasn't because they disagreed with its proposed contents, It's just that they were sharp enough to see what might happen. It was Alexander Hamilton who represented the Federalist point of view, and he argued against the creation of an enumerated Bill of Rights, and it was kind of a hotly contested issue. And his motivations for taking that position were very reasonable, because Hamilton contended that as soon as you spell out a defined set of individual rights, then those specific words could be used to rule in favor of the allowance or the prohibition of anything that wasn't specifically spelled out in that Bill of Rights as prohibited or allowed. Hamilton was very perceptive. The Bill of Rights was created, and now we can see exactly what Alexander Hamilton was predicting happening today. In the liberal interpretation of the Bill of Rights, they take exactly the position that Hamilton feared would be taken. There's no consideration of the original intent, just bending of the words to suit the need of the moment. For instance, in the modern liberal view, you can outlaw certain kinds of weapons because their allowance was not specifically spelled out when the Constitution was penned in 1789. After all, automatic rifles didn't exist back then. Therefore, by their argument, we can outlaw them without ever infringing on the rights that existed in 1789. Another example in the liberal view is that we can define what comprises the press to exclude bloggers and grassroots writers and Facebook participants, because the press in 1789 was only comprised of formal newspapers. The internet didn't exist yet. Private blogging didn't exist yet. Therefore, by their argument, bloggers and people who don't fit into a government definition of press can be excluded constitutionally from freedom of the press, from the freedom of the press rights that are guaranteed in the Constitution. Those are only two ridiculous examples, and both of them typify exactly the kind of constitutional abuse that Hamilton warned against. On the other hand, although that's why Hamilton didn't favor adopting a Bill of Rights, where would we be today had it not been adopted? Hamilton did lose the argument, and the Bill of Rights does exist. So now we have this resulting interpretational debate to deal with, just as Hamilton had predicted would happen back in the early days. What's the only logical answer to constitutional interpretation debate? Well, in my mind, original intent is the only argument behind which anybody can stand with any sort of logical validity. Original intent, that's easy enough to understand on the basis of history. What was transpiring that motivated them to write these things down during the period of the constitutional formation? If we can establish what the framers originally intended, that is, what the absolute meaning was behind their words, that must certainly take precedence over any sort of opinion about it or interpretation of what might be because it isn't there. Rulings about whatever the Constitution didn't say can logically be nothing but baseless, personally biased opinions. Such opinions are easy to spot because, without exception, they walk on someone's inalienable rights, and that's invalid. If you listen to Chris Ann Hall's audio piece, she explains this 1789 debate about whether or not the Bill of Rights should even have been written. And if you really dig into history, you'll learn that the party that believed that the Constitution was to give the people power over potential tyrannical government was the same party that won the debate over the issue of whether or not there should be an enumerated Bill of Rights. And because they won, the Bill of Rights was created and it was ratified, and that's what we live under. Now, I've been told by some liberal-minded friends that I need to read the Constitution because I'm supposedly misinterpreting it. Well, I did read the Constitution, and I do read the Constitution. In fact, I carry a copy of it in my briefcase. And I also read history. And I also consider the tyrannical actions of King George III, who inspired the colonists to revolt and to declare independence from his tyranny. That's what this country was about. What I haven't done, and which makes me incapable of constitutional interpretation, according to one of my esteemed well-meaning liberal friends, is to take a course from a liberal arts college law department, which teaches students to interpret the Constitution in exactly the same manner which Alexander Hamilton warned that it is not to be interpreted. So please go down, look at the links at the bottom of this video, listen to Chris Ann Hall's video, and look into Chris Ann Hall's products, and keep watching dailyunconstitutional.com for links to Chris Ann Hall's products and information as well. We're doing all we can to push her agenda into full swing. So thanks for listening. I will talk to you in the next video.